I'm Kenneth Marcus, founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law, and I want to welcome you to the Brandeis Center's Summer Speaker Series and to our event today featuring Professors Avi Bell and Ann Bayevsky on the current crisis, Gaza, Hamas, and Durban 4. The Brandeis Center fights anti-Semitism on college campuses using law and public policy as part of our mission to advance the civil and human rights of the Jewish people and promote justice for all. As part of our mission, we have had law chapters and jigsaw fellows at law schools around the country. The speaker series initially developed on law school campuses in as many as 18 law school campuses pre-COVID. During COVID, we've been able to take the series online and offer both to our law students and the general public an opportunity to hear from experts, especially legal experts, both on anti-Semitism issues and on related matters. For a number of years, we have instructed our law students not just on civil rights and human rights, which is our particular area of expertise, but also on certain matters involving international law, which we find arise on law school debates regarding Israel, the Middle East, and anti-Semitism. When we first scheduled this event, it was to address Israel and international law because we know that anti-Semitism is often fomented on college campuses as a result of misinformation and stereotypes about Jews, Israel, and Zionism. Avi Bell, a professor at the University of San Diego, has been a favorite instructor for our law students for many years now and frequently gives talks to them that help arm them with information and analysis and an ability to understand the international legal issues that goes beyond the superficial errors that we often hear. We're very pleased that Professor Bell, really one of the most incisive experts on international legal issues, especially surrounding the Middle East, that he is able to join us today. We're also pleased to have Professor Ann Bayevsky. She is the president and founder of Human Rights Voices, but she is a scholar activist who is also the director of the Touro Institute on Human Rights and the Holocaust. And at Touro, she is a professor at the Graduate School of Jewish Studies. She is certainly one of the leading scholars and analysts of the United Nations, and one of the top people looking at really the problems that arise from the United Nations today. In general, we've been concerned about the way in which Israel is misunderstood, the way in which Israel is stereotyped, the way in which Israel's enemies use a series of methods to try to take a law and international institutions to marginalize and demonize the Jewish states. But now this topic has become more timely than ever with the conflict raging in the Middle East. And so now we're especially pleased that we have these two experts today to share with you their knowledge on the topic of the current conflict. Avi Bell will be speaking directly on that. And Bayevsky will share in particular insights about the Durban 4 conference, which is to say the current and unfortunate effort to commemorate the initial Durban UN conference, which was really the basis for so much hate and anti-Semitism, which has stayed with us today. So Professors Bell and Bayevsky will speak in a moment, and after that, we'll have an opportunity to take questions. You can use the Q&A function to provide questions that we might share with the panelists, time permitting, after they give their presentations. In addition, my colleague, Aliza Lewin, will join us for a discussion afterwards. We will start with Professor Avi Bell, who joins us from Jerusalem. Professor Bell.
Thank you. So it's a great pleasure to be here. The topic is a little bit broad, so I will do my very, very best to fit this in with the time framework and to leave as much as possible for our later discussion. So let me begin with something that you all know. In Israel, we're right now in the midst of a military campaign. It involves dozens or even hundreds of daily launches of rocket attacks from the Gaza Strip by various terrorist groups, primarily Hamas, but also the Palestine Islamic Jihad and other terrorist groups against Israel's cities. And it involves counterstrikes by Israel's Air Force on Hamas targets, but also on the Islamic Jihad targets in the Gaza Strip. Now, one of the central parts of any one of these campaigns, and unfortunately, this is not the first such military campaign that has taken place between Israel and a terrorist organization. There have been several rounds between Israel and Hamas in 2014 and 2009. There have been several rounds between Israel and the terrorist organization that controls southern Lebanon, the Hezbollah organization. But in every single one of these, one of the central questions that's been raised repeatedly on the international stage is whether the campaigns are being conducted according to the international laws of war. Now, I'm going to give you the 60-second summary of everything you need to know about the laws of war in order to discuss that. It's all based on a short passage in a theological book, Theological Morality, by Thomas Aquinas. And it concerns the question of when it is lawful to undertake an action that has both good and bad results. I think that it's a fairly good analogy for what happens in military campaigns. And the way that Thomas Aquinas' answer has been adopted in the laws of war is this: that it is permissible to undertake a military strike when the military strike is aimed at enemy combatants or enemy structures that are in some way contributing to the military effort of the enemy. And it's permissible when those well-intended strikes cause collateral damage that is proportionate to the military need. That's more or less the rules of war. And it's fairly clear what happens in all of these campaigns. On the Hamas side, Hamas has launched so far, as I've said, more than 3,000 rockets. All of those rockets have been violations of the laws of war. They've been violations of the laws of war for multiple reasons. It's not simply that they were aimed, in almost all cases, at civilian areas. As Hamas actually announced today that it was trying, among its rocket attacks, to try to hit Israeli Air Force bases. This is a first for them, in which they announced that they were actually trying to strike at military targets rather than civilian. But in addition to the striking at intentionally at civilian targets, they've used weapons that are considered unlawful because they are unable to be targeted properly against military rather than civilian targets. And they're being launched from civilian areas with the intent of using the civilians around them to shield the terrorists. And that is a crime of using human shields. On the other hand, it's quite clear, especially to someone who has any knowledge of the Israeli army, that none of the Israeli attacks are problematic under the laws of war. I have enough students that are engaged in this that I know that every single airstrike in Israel is logged and approved by lawyers before it's undertaken, where the pilots themselves are instructed to exercise judgment when they see developments on the ground before releasing any ordnance. And the result is that everything is off of an approved list of targets that are military. So every single airstrike is aimed at a military target, and is approved only on condition that the anticipated collateral damage will be proportionate. So it's practically impossible for an airstrike by the Israeli Air Force to be a violation of the laws of war. But yet, that's not what we see when we see international coverage of this. It's not what we hear when we hear the statements of the European Commission or various members of the UN Security Council or various other politicians throughout the Western world. And what is the reason for that? The reason for that is not that there's some great insight into what's going on in the Israeli military and in what's going on with Hamas. With all due respect for, let's say, the European Commission, I think that its ability to gather superior intelligence on the way Israeli army lawyers make their decisions is, it's limited. I trust my own intelligence sources much more than I trust theirs. I think I have a better handle on what my colleagues and students are doing than European Commission bureaucrats sitting in Brussels or in Geneva. So what is it that they're doing? What they're doing is, unfortunately, a part of the Hamas campaign and the Hezbollah campaign in the other wars. It's a set part of the campaign, and the set part of the campaign is utilizing the rhetoric of international law, together with the expected ignorance of the audience to whom they are speaking, to try to justify adverse treatment of the Jewish state. The idea at the end of the day is to create international diplomatic pressure on Israel to stop using military force to defend its citizens, and to threaten Israeli soldiers and leaders with being placed in the docks in kangaroo courts, where it's presumed they will be found guilty and then tried. There's also, of course, no expectation whatsoever that any of the Hamas criminals, and I've simply spoken about their war crimes, they've also committed crimes of terrorism. Every single one of the rocket attacks is a crime under the International Convention for the Suppression of Terrorist Bombings, and other crimes that they've committed from treaties as far-flung as the International Convention for the so-called Genocide Convention. There's no expectation whatsoever that any of them will ever face trial anywhere in the world, and this is well known. Now, I wanted to touch very briefly on one other legal controversy that has emerged over recent weeks that is related to this conflict, and according to some, I think inaccurately, has led to Hamas's decision to attack Israel's cities. And I want to, at the end of it, wrap these two together and make some final concluding remarks in order to hand things over to Anne. So I'm sure that some of you, this one I'm not sure that all of you have seen it, but some of you must have seen that there are many of the critics of Israel have explained that there's a deeper cause. I think this is what the EU representative said in the Security Council debate, that there is an underlying deeper cause for the fighting that is not, it's not Hamas terrorism. It's not Hamas's open call for genocide against the Jews. It's not Hamas's aspiration, also openly stated, to destroy the state of Israel. No, says the EU representative. The deeper cause, the underlying cause of the conflict, the underlying cause of Hamas's terrorist attacks is Israeli misbehavior, and specifically what he described as settlement activity, and he's recent settlement activity in East Jerusalem, by which he's referring to a current case pending before the Supreme Court of Israel, involving a landlord, a corporation by the name of Nahalat Shimon, that has won eviction orders against 8 defendants, half of them squatters, half of them tenants that have not paid their rent, and against which the plaintiff has won an eviction order. Those eight defendants with the outstanding eviction orders that are awaiting appeal in the Supreme Court are the underlying cause, according to the EU representative, the underlying cause of Hamas's terrorist attacks. And the reason is that, according to the EU representative, because the plaintiff is Jewish and the 8 defendants in this landlord-tenant or landlord-trespasser dispute are Palestinian, this constitutes so-called illegal settlement activity. Now, settlements is one of the terms that you will hear in the international law rhetoric invoked frequently with regard to Israel. You will no doubt be surprised to learn that there is no mention in the relevant treaties of a term of settlement. Right? It does not. The Fourth Geneva Convention does not forbid settlements or settling. What the Fourth Geneva Convention describes in part is a prohibition on transferring populations. And what we are to understand from the EU representative is that when a Jew goes to court to enforce property rights and the defendant is a Palestinian, that is the state of Israel transferring Jews into territory where the Jews are not allowed to live. And it is the state of Israel deporting Palestinians from property to which they have no legal right. Now, I have to say that I've been given a number of lectures over recent days and weeks over the property dispute in Sheikh Jarrah, and when giving a lecture like this last week, I encountered a very, very frustrated audience member who wanted to know what is the best legal argument that the Palestinians can make for why Israel is violating international law. And I had a very difficult time articulating it. And the reason is there is no coherent argument. I just gave you the best one, that somehow or another, if Israel respects private property rights, it is violating an imaginary prohibition on settlements because the private property rights here belong to a Jew. I've heard all sorts of other very bizarre explanations of somehow or another this is supposed to violate international law. Frankly, they're not coherent, and I don't think that they have to be coherent because, of course, nobody's really interested in that. In this, too, the EU is playing the same game as Hamas. It is using international law rhetoric as part of its propaganda campaign to achieve its aims. Now, I think that what we're looking at overall is a picture that is actually beyond what Ken was saying in introducing me. Right? What Ken said was that we often see that the rhetoric of international law is used to demonize Israel, and that is part of a broader effort to delegitimize Jews and the practices of Jews, the beliefs of Jews, to make the environment difficult for Jews on college campuses and elsewhere. And that's true, but that's not all that happens with international law rhetoric. The international law rhetoric that I'm talking about, the use of international law rhetoric to try to paint the terrorist Hamas organization as victims and the law-abiding Israeli military as war criminals. The use of international law rhetoric to describe Israeli courts as engaging in some criminal activity by upholding property rights of Jews. That rhetoric is designed to discriminate against specific Jewish people. They are to be denied their rights to defend themselves. They are to be denied their rights to engage in military activity to defend their mothers and fathers and sisters and brothers and children at home. They are to be denied the rights to recover possession of property they own, property that their predecessors entitled purchased in 1875, and they've had for 150 years. The rhetoric of international law goes well beyond the justification for violence against Jews, although of course it is used that way. It is also used specifically to discriminate against Jews, to put a legal covering on actual quantifiable and measurable bigotry against Jews that deprives them of rights. All right, that's I hope a good enough introduction to our discussion, and I'll turn things over to Anne.
Thank you, and thank you to the Brandeis Center for convening this webinar. I think, as Professor Bell indicated, what we have is a two-part strategy. The first is military, or first or second, however you want to put it. Military is to promote violence, is to use violence to secure the end of a Jewish state. Military action is only one way of accomplishing this goal. The other is political. And the lie that a Jewish state is a racist state, because, as we know, a racist state is delegitimized, is a crime, is not entitled to survive. So South Africa, as an apartheid state, was delegitimized and ultimately fell. The effort to marry or to link Israel, a Jewish state, with a racist state began over half a century ago. It's not new. The link has been made between Israel and apartheid South Africa way back in 1975 or earlier. And we know that in 1975, the General Assembly adopted a resolution saying that Zionism is a form of racism. Zionism, the self-determination of the Jewish people. Now, it took 19 years, well, actually a little bit less than that, but till 1991, I should say, for the General Assembly to rescind the Zionism is racism resolution. And when it did so, there was an effort by the supporters of the Zionism is racism resolution, it wasn't unanimously rescinded, to think of another way to say exactly the same thing, that a Jewish state is a racist state. And that's what the Durban Conference was all about. So in 2001, the UN convened a global conference against racism. It was a so-called anti-racism conference. The problem was that it was a racist anti-racism conference. And I attended it on behalf of the International Association of Jewish Lawyers and Jurists, and I could go into it in great detail, but I will tell you that it had two parts, an NGO forum and a governmental forum. And there is considerable misinformation about the original Durban conference. Some say it was the anti-Semitism on display was only an NGO problem. It wasn't a governmental issue. That's patently false. In the NGO forum, indeed, there was adopted a declaration saying that Zionism was a form of racism, calling for the elimination of a Jewish state, the readoption of the Zionism as racism formula. There were violent demonstrations in the street. Signs depicted apartheid Israel. The Jewish Community Center was shut down, and we were forced to end our meetings on what was going on because of threats of violence. At the end, the declaration, the NGO Forum Declaration, was adopted by a vote which eliminated the expression of concern by Jewish organizations that about the anti-Semitism and the treatment of Israel as a form of anti-Semitism. We were then escorted immediately after that vote off the premises because the South African police said they couldn't protect us. So this is a human rights environment that the UN facilitated. It then moved to the, by the way, the world's major organizations, NGO organizations, Amnesty International, Human Rights Watch, the Lawyers Committee for Human Rights, now called Human Rights First, refused to vote against the Zionism as racism declaration of the NGOs. So it moved to the government conference. At the government conference, you had Congressman Tom Lantos, the only Holocaust survivor to serve in Congress, and Colin Powell, the Secretary of State, working side by side to try to get a better outcome in the government conference. Colin Powell didn't attend. The head of the delegation was Tom Lantos. And in the end, when it became perfectly obvious that they couldn't eliminate the grotesque anti-Semitism from the Durban Declaration itself, the Americans and the Israelis pulled out. So the end result was a declaration which says that Palestinians are victims of Israeli racism. And Israel is the only country in the entire world in a global meeting on racism that's named in the Durban Declaration. So Durban is clearly a example of modern anti-Semitism, right? You have Israel, the only country named in a global so-called anti-racism manifesto, and Israel is singled out as victimizing anybody in the world for racism. So this formula became the centerpiece of the UN's anti-racism agenda. But the grotesque situation that was so visible to the outside world was enough to discredit it. 3 days later came 9/11. I happened to go directly from the Durban, South Africa conference to New York City. And anybody who witnessed both Durban and 9/11 could readily connect the hatred with the violence, the xenophobia with this anti-democracy, anti-human rights, anti-freedom, and among other things, anti-Jewish phenomenon. And but the United Nations decided not to give up. And the UN High Commissioner for Human Rights, a woman by the name of Nabe Pillay, who was herself, actually, her hometown was Durban, South Africa, decided to take it upon herself to resurrect, to revisit the Durban conference and its declaration, and to lend it renewed credibility. So in 2009, they held the Durban Review Conference. It was held in Geneva. The headliner of the Durban II, or the Durban Review Conference, was Iranian President Mahmoud Ahmadinejad. And he was the only head of state to attend. And he stood up with the Secretary General behind him and the UN High Commissioner for Human Rights behind him. And he said, first of all, he questioned the veracity of the Holocaust. And then he said, the word Zionism personifies racism that falsely resorts to religion and abuses religious sentiments to hide their hatred and ugly faces. Did the UN High Commissioner stand up and walk out, or the Secretary General? No, they did not. They had the speech, by the way, in advance of him delivering it. So that was the Durban Review Conference, and Ahmadinejad did the work for the Jewish community and other supporters of Israel and other true believers in combating racism, and continued to discredit the Durban phenomenon and Durban process. But Navi Pillay didn't stop there. In 2011, she decided she wanted to convene, with the help of the General Assembly, a 10th anniversary. And the 10th anniversary would take place in September of 2011. And it would be held in New York at the same time as the opening of the General Assembly, so that all the heads of state were there. And they would adopt a political declaration reaffirming the Durban Declaration, and thereby would lend it global support. Well, fortunately, a number of democratic states decided not to attend, just as they had done, I should have added, in terms of Durban II. And it was boycotted by all three members, democratic members of the veto-holding members of the Security Council, the British, the French, and the Americans, in addition to other countries like Canada and Australia. Durban, Ahmadinejad did come for the opening of the General Assembly again, and there was a counter conference where, you know, the spokespersons were people like Elie Wiesel, Ed Koch. It was a bipartisan effort in the United States, and Senator Huckabee, and it was across the board an understanding that the Durban message was antithetical to American values. So Durban continued to be discredited. However, the forces that continue to reject a Jewish state and Jewish self-determination were in it for the long haul. And here we are, the 20th anniversary of the Durban Conference, about to take place in September of 2021. And so in December 31st of 2020 of last year, they adopted a resolution to commemorate once again the anniversary of the Durban Declaration. Now, the cynicism surrounding this 20th anniversary is almost unimaginable. They decided to bring together not only the call for the full implementation of the Durban Declaration, which means the lie that a Jewish state is a racist state, and to marry that to the theme of concern for peoples of African descent. Now, elsewhere in the resolution, it had talked about Africans and people of African descent. But when it came to organizing the 20th anniversary of the Durban Conference, they omitted the African part. So it's only about, the theme is peoples of African descent. So Africans subject to slavery in Libya, for example, Africans subject to xenophobia and ethnic strife in other places in Africa, not on the agenda. Only peoples of African descent, not only because obviously with legitimate concerns about racism, but to target the United States in particular. And as I say, it's not intended to be global or to be concerned about a broad swath of people suffering from xenophobia and racism, but to be highly targeted in its campaign. And so it will have two parts: peoples of African descent and a political declaration that will call for the full implementation of the Durban Declaration. So Zionism is Racism is about to be adopted in September by the global world, the global, I should say, membership of the United Nations, unless countries pull out. So to get quickly to what has happened since then, in February, the Biden administration decided to join the Human Rights Council again, or they'll run for election in the fall and no doubt be elected. And as part of that, they led a racism resolution, an anti-racism resolution, which talked favorably about the Durban 20th anniversary. This raised alarm bells around the country, and it was after some clear statement that how this was a dramatic change of bipartisan policy over the previous 20 years of walking out of Durban 1 and not attending Durban 2 and 3. The Biden administration decided that they would declare publicly that they would not attend the Durban 4, what is in effect Durban 4, in September. This was followed by the Canadians and the Australians. The Australian Prime Minister, in his language in early May, just a couple of weeks ago, "I do not accept that anti-Semitism, cloaked in the language of human rights, serves any justified purpose nor the cause of peace." So that that Australia did not attend Durban 2 and 3, and we will not be attending it going forward. The Canadians said something similar, that Canada opposes initiatives at the United Nations and in other multilateral forums that unfairly single out and target Israel for criticism. Canada is concerned that the Durban process continues to push anti-Israel sentiment and is a forum for anti-Semitism. And so Canadians have got out too. However, the British have not done so yet. In fact, the matter was raised in the House of Lords today again. And so far, the Foreign Ministry in Britain, the Foreign Office, is saying they don't have enough information, they have to wait and see. This is false, because the General Assembly resolution from the end of December already says that there will be a political declaration and it will call for the full implementation of the Durban Declaration. And they even set the date, September the 22nd. So Germany has said in private correspondence that in the last 2 days, that it is also going to wait and see. This is a shocking development vis-a-vis a country which has a unique moral responsibility to stand up against anti-Semitism. And so the fact, what I'm just going to quote it because it's so incredible. The Durban, I should say, Germany, Michaela Kuchler, who is the Minister for Jewish Affairs and Anti-Semitism, said, the schedule for the opening week is not yet fixed at this very early stage, and the precise details of the planned event are still unclear. It is therefore not possible to make a decision. This is a lie. The schedule has been set. It's September the 22nd. The relevant detail has been planned by the General Assembly to have a political declaration, calling for the full implementation of the Durban Declaration, and the lie that an Israeli state, a Jewish state, is a racist state. And so France, with its the horrors of elderly women being able to be killed because they're Jews with impunity, has still not pulled out. And so we wait. And I encourage people to make their voices heard. This is completely unacceptable for these countries not to join forces with the United States, Canada, and Australia to pull out of Durban and to reject once and for all the lie that a Jewish self-determination is somehow xenophobic or racist in itself. Thanks.
Thank you. Thank you both, Professors Bajewski and Bell. At this point, with about 15 minutes remaining, if Professors Bajewski and Bell are amenable to responding to questions, I'll ask them to return. Together with my colleague, Aliza Lewin, who will also join for discussion. Aliza is the president of the Louis D. Brandeis Center, a founding partner of Lewin and Lewin, and past president of the American Association of Jewish Lawyers and Jurists. Again, I want to thank the speakers for their excellent presentations, and to suggest that if audience members have questions, they put them in the Q&A box. But for now, I'll start by asking whether Aliza Lewin would like the privilege of the first question.
Sure. Thank you, Ken, and thank you, Avi, and thank you, Anne, for wonderful presentations. Isn't the crux, I think, of the matter that both of you have really pointed at, isn't the problem that many people today do not recognize the notion of Zionism equals racism as anti-Semitism, right? Unfortunately, what we have today is a society that has a very narrow definition of what they think anti-Semitism is. They think that anti-Semitism is targeting somebody based on their religion, purely on their religion, targeting a Jew who's an identifiably Jewish, or engaging in the anti-Semitism of the Holocaust, of the Nazis, the swastika, right? But the idea of recognizing Jews, not just as a religion, but as a people entitled to a Jewish homeland. And when we talk about a Jewish homeland, we don't mean a Jewish homeland where religion is the law, right? We mean a Jewish homeland, a homeland of the Jewish people. The notion of that Jewish homeland now and calling it racist if the Jews are entitled to once again exercise self-determination in their ancestral homeland. Judaism is deeply intertwined, right, historically with this place. This is the birthplace of our people. And to be told that, no, you cannot exercise your right to self-determination there because that's racist, that is actually, right, the contemporary form of anti-Semitism. If the idea is that anti-Semitism historically has taken whatever is that generation or that century's greatest evil and pinned it on the Jew, so today's greatest evil, today's misfortune is viewed as racism, apartheid, settler colonialism. And what's happening today? The world is deciding, as you pointed out, Anne, there was no other country that this international conference at Durban pointed a finger out other than the one tiny democracy in the Middle East where all ethnicities, all religions, all genders, all races are all equal under the law. That's the country that they decided doesn't have a right to exist and is racist in its creation. That's today's anti-Semitism, and yet most of the world doesn't recognize that as anti-Semitism. So how do we get the world to understand that that is today's anti-Semitism? And I ask either or both of you.
Anne, do you want to go first?
Well, I was going to say Ken's the expert.
But you're the two of you are the speakers, and I think it's important to hear from you both the general answer to that question, well, in an international relations and international human rights context.
Well, I think in an international human rights context, look, it's a matter of context. It's no country is perfect. You know, and so we begin with the human rights idea that rights are universal, that the United States has work to do, obviously. Canadians, Australians, Israel also. And so so one looks at who is promoting the lie that Zionism is racism, or singling out a Jewish state, I should say. And that's why Ahmadinejad matters, that Durbin is a favorite of citizens and countries and players that have no real serious interest in human rights. So who are your friends? When you begin to have friends like Ahmadinejad, it ought to give you pause about the message and the vehicle for accomplishing your goals. And that's one way of cluing in to maybe you're not doing human rights. And also, as I say, the cynical disinterest in all Africans, the fact of wanting to of only Israel in an anti-racism document, that when you look around the world and you see genocide and ethnic strife and horrors of such magnitude, the Uyghurs, the et cetera, and they're nowhere to be found, then that ought to give you pause about whether you're really doing human rights, and let alone multilateralism. I think I should have said this before. Durban, the argument is sometimes made, well, we need Durban because otherwise we can't come together. You know, all multilateralism is good. Well, that's simply not true. There are other multilateral cooperative vehicles, international human rights vehicles for combating racism together, cooperatively, legitimately. Durban is not that vehicle, because Durban purports to build equality rights on the inequality of the Jewish few. That's anti-Semitism.
So, if I could add something, I agree with everything that Elisa and Anne you just said, but I think that there's another way of looking at it that's also valuable, and that is to understand that we're looking at a broader phenomenon. It's not simply that Jewish self-determination is being described or redefined as a form of racism or apartheid. Also, Jews living in lands where they're not supposed to live, where they're not wanted, is being defined as a war crime. The Jewish state defending its civilian population from terrorist attacks is described as a war crime. And we see all these things separately, when what we should really see is all of them together. And what you're seeing is a phenomenon of adverse treatment of Jews, the creation of myths of Jewish evil, all these different components of anti-Semitism that have roots going back for thousands of years. And they're being disguised. They're being disguised as something moral or as something legal. And that too is not, that's not new. That's quite old. And so when you would see medieval Christian anti-Semitism, pogroms against Jewish communities, they would say, no, this has nothing to do with anything about Jews. This is not hatred of Jews. It's that those people are poisoning our wells, or those people are spreading disease, or those people are murdering our children for ritual purposes. And these days, the way it's described is those people are intrinsically racist. Those people are all war criminals and murderers of children. Those people are carrying out apartheid systems. And that way, it is possible to say that it's the reason that we are mistreating Jews, the reason we're demonizing Jews, the reason we're trying to strip Jews of the rights that we afford everyone else in the world has nothing to do with bigotry. No. It's actually a fight against racism. It's a fight against apartheid. It's a fight against war crimes. And for that reason, I think that it's important not just to strip away that, Zionism is racism, it's a strategy for whitewashing anti-Semitism, but to see this more generally. All of these attempts to fit the bigotry within some notion of fighting on behalf of international law or fighting against some imaginary racism. All of these are just ways of trying to whitewash bigotry against Jews.
Thank you. With only approximately 5 minutes remaining, I will dispense with my own question in order to take at least 1 or 2 questions from the audience. I will observe that we have an impressive audience composed not only of Brandeis Center law students, but also professors of law and other subjects, at least 1 senior civil servant, and various activists and professionals from various other organizations. One of our Brandeis Center Jigsaw Fellows, a law student, asked the following question that I take to be directed to Professor Avi Bell. He says the following: many argue that Israel's application of property law is biased, that Israel will respect title when land was confiscated from Jews by Jordan, but not for Arabs when Israel confiscated the land, regardless of how the Arab or Palestinian left. How does this accusation fit in with Professor Bell's views?
Okay, so I'm going to try to answer this very quickly, so we'll get to something else. And I'll just say that your assumption here is incorrect. It's not, I won't blame you for that, because of course it's a commonly stated assumption that there's some sort of bias in the property law that allows Jews to recover title when land was confiscated by Jordan, but not Arabs when Israel confiscated the land. I saw that at least half a dozen times in the last week in the New York Times, but it has no correspondence with reality. It's simply, it's false, okay? So let me start with the very basic thing. No one has the right in Israel automatically to recover sequestered property. Sequestered property is the correct term. It's a term in international law. It refers to the taking custody of property of civilians of enemy states, or enemy property, as it's called. It's a very common practice. It's mentioned in the commentary to the Fourth Geneva Convention as a universal practice. It's not simply Jordan that's done it, and Israel that did it. The British Mandate did it. The Ottoman Empire did it. The United States did it. There was a Trading with the Enemy Act during World War I and World War II. It's a quite common practice, and the way it works with sequestered property is that the custodian takes possession of the property and may dispose of title. If the custodian gives title to someone else, that title is considered to be valid, but otherwise it's expected that the sequestered property will be returned at the end of the conflict, or compensation will be paid. Now, that's the way sequestered property works in Israel as well. Whether you're talking about Palestinians or Jews, property that's been sequestered in most cases is no longer available for being restored to its original owners because title is passed on to someone else. But if it was Israel that did the sequestration, Israel's preserved money for compensation at the end of the conflict. Of course, Jordan did not do this. Jordan simply sequestered all Jewish property in the territories that they conquered. But what Israel did has over the years done is it has released some of the sequestered properties back to their original owners, in some cases Palestinian owners, and in some cases Jewish owners. The reason that there's this misconception is that in 1970, Israel adopted a law saying that the properties that have been sequestered by the Jordanian custodian of enemy property during the period of the Jordanian occupation from 1948 to 1967 would be returned to the owners if title had not already passed on. It did not refer to Jews. It did not refer to Palestinians. It was not the only time that sequestered property was released, but it was released to those who owned it and where Jordan had not passed on title. The Sheikh Jarrah controversy involves properties that were sequestered for this short amount of time by the Jordanian custodian. And from this, various commentators have fabricated a generalized right to release sequestered property, which does not exist, and projected an ethnic discrimination that simply isn't there. It's not there in the laws.
Very good. So with 1 minute remaining, I have to say I don't think we have a short question, and I'm not sure that we have time for a long question, but I do thank those audience members who have contributed to the chat or otherwise. I want to thank again Professors Avi Bell and Ann Bajewski, and also Eliza Lewin. And for all of our audience members, I would like to remind you that our summer speaker series continues through the summer. Next, on June 9th, we will have Mark Rotenberg, a very distinguished, experienced, and knowledgeable higher education lawyer, now with Hillel International, but former general counsel with a number of universities, who will address academic freedom and the fight against anti-Semitism. Again, Avi Bell, Ann Bajewski, Eliza Lewin, thank you. And to our audience members, thank you for watching.